So now we are going to start with the revision of this very important revision actually. In my recent revision Super 35, all those revisions also I did not do this. Now we are going to first do the incorporation of company and incidental matters. So let us start with revision of the chapter incorporation of company and incidental matters. 10 marks you can expect from this chapter also. Okay, I will show you one thing. See here. See here. The highest weighted contents, I will tell you. Prospectus over, share capital over. Okay. Next, deposit charge 2 marks, 4 marks areas. Charges optional. It may come, it may not come. Management administration already I kept in the YouTube. If you want, you can see there. The dividend over, accounts over now. Foreign company over, LLP same as Companies Act, nothing great. General clause interpretation is more important, completed. FEMA is also completed. Substantial, if you count these marks, if you see in the last examination, May 24 exam also, if you see, prospectus 2 marks, share capital 15 marks, 17. Okay. Next, after that, management administration 13 marks. How much? 13. So 15 plus 13, 28, 30. 30 plus 5, 35. 35 plus accounts of company 10, 45. 45 plus foreign company. Auditors, no, we did not cover. Foreign company, that attempt it was not asked. Last attempt it was tested. Okay, 6 marks. 50 marks. Next, LLP 10, same as companies at 60. After that, interpretation of statutes 8, 68. 68 after that 8 to 70. Almost 70, 75 marks will be covered here itself. Okay. So that's why concentrate more on the subjects or that chapters which are more important for your examination. Sir, anyway, let me do one thing for incorporation chapter. From the last I will come. Recent questions first we will cover. I will cover 10 questions in this chapter. All important questions I will cover. Let's focus. Satvika Private Limited was formed on 25th April 2020. At the time of formation, it had provided in its articles that the company shall not be permitted to accept or keep advance subscription or calls in advance subscription or call money in advance. However, in August 2023, the need was felt to amend the articles with respect to retention of calls in advance. Okay, decide whether provision inserted in the articles at the time of formation of the company can be considered as void. Okay, read the question. RTP question, very good question. Read the question properly. Okay, read the question. See, what happened in this question? Satvika Private Limited was formed on 25th of April 2020. At the time of formation, it had provided in its articles that companies shall not be permitted to accept or keep advance subscription or calls on money and advance. See here, as per section number 50, whenever company wanted to accept, okay, from any of the member, any money which is not yet called, but need to be paid, simply if it want to accept the calls in advance, provision must be contained in the articles. Okay, it has provided in the articles that companies shall not be permitted. That means original articles of association, they said that it is not permitted to accept the calls in advance. Later, now they wanted to do that. Okay, call money in advance, they wanted to add, amend the articles. Is it possible? First, let us see the section 50. Acceptance of call money in advance, which requires such acceptance, can be made only if the company authorized by articles. Section 6. Save as otherwise expressly provided, the provisions of the Act shall have effect, notwithstanding anything contrary contained in memorandum, articles, agreement, or resolution of general meeting or by board of directors. Simply, Act will always be superior to memorandum, articles, agreement, resolution of general meeting, or resolution of board of directors. Understood? Any provision contained in memorandum, articles, agreement which is against to the Act will become void. Okay, in simple words, the provisions of this Act shall have overriding effect. It also be noted that save as otherwise, it means that if any other section of the Act says article is superior, then we will treat accordingly. Hence, in the given case, articles of Satvika Private Limited provide that companies shall not be permitted to accept subscription or call money in advance. Accordingly, here such provision contained in the articles of association will prevail and cannot be considered as void. Simply to tell, the question is, the articles of association of the company, provided that it shall not be permitted to accept the calls in advance. Is it correct or not correct? Correct. It can provide like that. Okay. In the Act, they said that in the calls in advance section, they said whenever you wanted to accept the calls in advance, article should authorize. Here, articles is not authorizing, therefore not permitted. Okay. However, August 2023, they wanted to amend the articles, decide whether provision inserted in the articles at the time of formation is void. It is not void. Happily, you can provide. Okay. Generally, Act to override articles, but the section 6 contains save as expressly provided. Means if any other place articles are given more superiority than Act, follow that. In all other cases, Act will override the articles. So, even though section 50 permitted calls in advance, if articles prohibit it, you cannot accept calls in advance. Later you can amend. But the question is not on how to amend articles. Question is on the inserted provision is valid or not is a question. Next. Articles of Association of AB Limited provides that document may be served upon the company only through speed post. Okay. Suresh dispatches some document to the company by courier under certificate of posting. The company did not accept it on the ground that it is a violation of AOA. As a result, Suresh suffered a loss. Explain with reference whether refusal of document by the company is valid, whether Suresh can claim the damages. Listen, there is a section called as section number 20 that says that any document which you require to serve on the company or any officer of the company like directors etc, where to serve, it should be served on the company registered office. For example, I wanted to communicate with the company. Where to communicate? You have to communicate with the registered office. Okay, in what way? Either in the registered post or by speed post, courier, or directly go to register office and give, or by any electronic mode. Okay, so courier is a valid means or not? Yes. So articles cannot go beyond the Act. Just now we read in section 6, same. So in the instant case, Suresh dispatches some documents through courier. Okay, through AB Limited did not uh, accept the documents on the ground that it is violation of AOA. Act has given me 5 chances. Who the hell articles to tell that I will not allow? Act is allowing. So refusal of document is not valid. Okay. Next, whether Suresh can claim damages? Yes, it is not. Since AB Limited is at the fault by not accepting, yes, he can claim damages. Next, Sapphire Private Limited has registered its articles along with its memorandum as on 1st July 2021. Directors of the company seeks your advice regarding effect of registration of company on the company itself and on the members. See here. Section number 9 of the Companies Act says that what is the effect of registration? The moment memorandum and articles are registered with ROC, incorporation will be done. The first thing that happens is company will become a body corporate. Okay, it can have all the functions of a body corporate like the separate legal existence, limited liability, perpetual succession, capacity to sue. It can own its own properties. It can acquire its own properties. It can hold the properties. Such registered companies capable of exercising all the functions of an incorporated company. Perpetual succession, acquire its own property, sell its own property, sue and can be sued. Sue and can be sued. And memorandum and articles once registered, it will bind the company and all the other members. Okay, next. This is a private company question. Directors and relatives are 18. Private company maximum number of maximum number of members are only how much? 200. Maximum limited 200 limit. Okay. There is a public company. Public company no limit. Then why they gave this public company want to get converted into private? Once converted, 200 is the limit. Let us check. Directors and relative counted, not counted, counted. Employees, nothing said na present employees we assume. So not counted. Ex-employees, shares were allotted during employment. No problem, not counted. Members holding the shares jointly, 7 into 2. We will not consider as 14, we will cover as 7. Next, other members, 137. Other members, 137. Okay. So now see, 137 plus 7, how much? 144. 144 plus 18, it is within 200 or not? Yes. So conversion can be there. Whether existing member need to be reduced? No, not required. See, that's it. 18, 7 and 137. That's it. Answer is over. So no need of conversion. There is no need of reduction. Next. S Limited acquired 10% paid up share capital of H Limited. Let us see. S Limited acquired 10% paid up share capital of H Limited on 15 March 2017. H Limited has acquired, okay, 55% of the paid up share capital of S Limited on 10th March 2018. H Limited on 25th September 2020 decided to issue bonus shares in the ratio of 1:1 to the existing shareholders. Okay, H Limited wanted to H Limited on September 25, 2020 decided to issue bonus shares in the ratio of 1:1 to the existing shareholders. Accordingly, bonus shares were also allotted to S Limited. Examined under the provisions of Companies Act, validity of holding shares by S Limited in H Limited and allotment of bonus shares. This is a question. Very, very good question. This is on section 19 of the Companies Act. Listen carefully. See here. Let us have a clarity with a diagram. Okay. See here. S Limited, H Limited. S Limited acquired 10% of paid up share capital of H Limited on 15th March 2017. H Limited acquired 55% of the paid up share capital on 10th March 2018. The moment H Limited acquires 55% in S Limited, S Limited became subsidiary to H. H Limited became holding company to S. Clarity. Once it becomes subsidiary, subsidiary cannot hold the shares in holding company, except three exceptions are there. Okay, as a trustee it can hold. Subsidiary cannot hold the shares in holding company once after it becomes subsidiary. Before acquisitions, no problem. That means 10% is acquired before becoming a subsidiary. For this, no problem. But for this, voting rights will not be given. But holding is okay. Okay, but any acquisition after becoming subsidiary not allowed. Not only acquisition, holding company also cannot allot the shares to subsidiary company after becoming a subsidiary. See, as per section 19, no company shall hold any shares in its holding company, or holding company shall not allot any securities to any subsidiaries, and any such allotment made is void. Okay, next, but any acquisition made by subsidiary in the holding before becoming subsidiary is valid. So 10% is valid. However, this shall not apply where subsidiary is a shareholder even before it became a subsidiary company. of the holding company. In the given case, H Limited has acquired how much? 55% of the paid up share capital of S Limited on 10th March 2018, whereas S Limited has been holding 10% on 15th March 2017. Said instance fall under the following. Holding of shares. Holding of shares in the valid provisos of proviso C2 subsection number 1 of section 90, we state that restrictions of provisions under 19.1 will not applicable where subsidiary company is a holder even before it becomes subsidiary up to their valid, but allotment of bonus shares, okay, allotment of bonus shares by H Limited to S Limited is also valid in the view of the above provision. But actually, bonus shares if they issue, who issue? H Limited issued to S Limited, automatically it become allotment. Okay, this answer as per the ICI is not correct because bonus shares cannot be issued. Clearly what they said, see here. Holding company shall not allot or shall not transfer, okay, to any of its subsidiaries, and any such allotment will become void. However, this shall not apply when the subsidiary is a shareholder even before it became a subsidiary company of holding. In the given case, H Limited acquired 55%. Okay, whereas S Limited has been holding 10% paid up share capital. The said instance as asked in the question fall in the exception. No, 10% allowed. On that 10, if you give bonus shares, it is an allotment after becoming a subsidiary. Na? So, bonus shares are issued after becoming a subsidiary, which is not allowed. 10% allowed. On that 10%, if you give bonus shares, that is not allowed. But answer was given in a different way, but that's not right. Next. 3 marks. See what is the question. Chavish, an Indian citizen or Indian resident, formed Ekta Readymades Garments OPC, a OPC company, on 1st April 2018 with his wife, Mrs. Jyoti, as a nominee. The authorized and paid up share capital of company is 35 lakhs. Okay, he got in touch with a ready-made garments buyer and was expected to receive substantial order by August 2020, where final delivery will be completed by December. To expand the production activity, they decided to invest an additional capital of 10 lakhs in plant. As a result, company's authorized share capital is now 45 lakhs. Promoter of the company seeks your advice considering the reference. Who is eligible to act as a member? Whether Ekta Garments Private Limited can convert into any other kind of company. If company increases the paid up share capital by 30 lakhs, okay, can it be converted into any other kind immediately? Read the question first. Read the question first. So it's now talking about one person company. Okay, who is eligible to become a one person company? Memorandum of one person company will name a other person who is a nominee, who shall in the event of the subscriber's death, he will become the member. But that person should be a natural person, Indian citizen and a resident. Okay. And next, only those shall be eligible to incorporate and shall become nominee. Amendment after what happened is OPC can be voluntarily converted into any company except Section 8 company. Amounts are not required. Hence, after amendment, there is no restriction to convert one person company. Happily, you can convert. Okay. Next, examine the validity of the following different decisions and proposals regarding change of the office. Registered office is shifted from Thane, local limit of Thane district, to the Dadar, local limit of the Mumbai district, both places falling within the jurisdiction of ROC Mumbai, by passing special resolution but without obtaining the approval of regional director. Okay, if you want to change within the local limits of the state, okay, sorry, within the local limits of a particular place, from one place to another place, if you wanted to change, okay, without any kind of change in the ROC jurisdiction or a state jurisdiction, first board approval is required, next special resolution. RD permission not required. Okay, see, where register office is shifted from Thane to Dadar, falling under jurisdiction of same ROC. As per section 12.5, which deals with change in register office within the local limits of the time, okay, special resolution is required. Correct. Okay, next one. Next one. Registered office is situated in Mumbai, Maharashtra, within the jurisdiction of registrar, Mumbai, whereas corporate office is situated in Pune, Maharashtra state. A Limited proposes to shift corporate office from Pune to Mumbai. So from one ROC to another ROC you are changing, then procedure will be lengthy. First, what we need to do? First, take a board approval. Second, take the special resolution. Third one, you need to apply for the regional director for his confirmation. Okay, you should apply to the regional director. Regional director has to give the confirmation yes or no within 30 days. You need to file that copy of yes or no confirmation of RD with ROC within next 30 days. ROC should confirm the change in the register office from Pune to Mumbai, and by giving a fresh certificate of incorporation in the new office within a period of next 30. So 30, 60, 30. So you should file with RD. RD should confirm within 30 days. File with ROC in 60 days. ROC issue fresh certificate of incorporation within next 30 days. Shifting of register office only. In the second case, corporate office is being shifted. Okay. But in this case, you see the question first. Registered office is situated in Mumbai. Corporate office is in Pune. Section is talking about shifting of register office only, not about corporate office. So corporate office is out of the purview of the section. That's the question answer. Section 12 talks about shifting of register office. In the second case, corporate office is being shifted under the authority. Shifting of corporate office, board resolution is valid. It may be assumed that corporate office and register office are same. Okay. If you assume in the exam hall, corporate office and register office is also same, then what you have to do? Then you have to write the entire answer what we said. Therefore, assuming the answer. The register office is situated in certain place of a city within the same local limits of the city. Means what? I don't want it to shift from one place to another also. For example, it is in Hyderabad. Hyderabad, Jubilee Hills to Banjara Hills, I wanted to change. Just one area is changing, nothing great. Chennai, West Mammalam to T Nagar, I wanted to change. City also not changing. In that case, special resolution also not required. Board approval is enough. That's it. So, register office change question also completed. Okay, next, doctrine of indoor management. All right, just 5 minutes I will explain what is this doctrine of indoor management and construct a notice. Whenever, as per section number 399, as per section number 399, whenever the company memorandum and articles are registered, they become public documents. Since they become public documents under section 399, every person, since it is a public documents are those documents which can be inspected by anyone in electronic form. Not only just inspection, they can also take the copies. Since members also have the access, every person dealing with the company is assumed to have the knowledge of memorandum and articles, understood in a right sense. Then only they are entering into contract with the company. If they don't read the memorandum articles and later something happened to them, law will not protect them. So doctrine of constructive notice protect the company against the outsiders, not the outsiders against the company. One point. Now indoor management. Indoor management says that once the Articles, memorandum and articles of a company which are registered are properly read by the person, understood in a right sense, and understood the particular contents of the memorandum and articles in a right sense. They need not inquire about the internal irregularities and regularities. Means articles of association, memorandum of association, outsider has to read. Articles of association, outsider has to read. I will read and confirm those. My work I will do properly. Once I read the memorandum and articles properly, I need not inquire into whether resolutions are properly passed as said in the articles. Company in the constructive notice, company is presuming that I read memorandum and articles and understood in a right sense, though I didn't read. Now I also will assume, being a outsider, I will also assume that I read memorandum, I read articles, understood in a right sense. Now I will assume that whatever is said in the articles, company complied it properly by passing resolutions. So this is a doctrine which operates in favor of outsiders against the company. Okay, see here. Company cannot be assumed to have a knowledge of internal problems of the person dealing with the company, cannot be assumed to have the knowledge of internal problems of the company. They can, means outsiders can assume that all required things are done properly. They need not inquire whether meeting was convened properly. That is not my work. They can assume. They are entitled to take it for granted that company had gone through all the proceedings in a regular manner. Am I clear? That's what you have to write. At least up to here you should write. Next. Doctrine of indoor management evolved 150 years ago in the context of doctrine of constructive notice. The role of doctrine of indoor management is opposed by the rule of doctrine of constructive notice. The doctrine of constructive notice protects a company against outsiders. Indoor management protects outsiders against the company. Okay. So what happens? Basics of doctrine of indoor management. What happens internal to the company is not the matter of public knowledge. An outsider can only presume that intentions of the company, but not to know the information to which it is not privy to. Next. Exceptions to the doctrine of indoor management. Doctrine of indoor management does not work in three cases. What is doctrine of indoor management? Whenever a person dealing with the company read the memorandum, read the articles, understood in a right sense, he need not he need not inquire into the internal policies and procedures of a company. As far as the internal regulations and compliances are concerned, I will presume that everything is done properly. Okay, everything is done properly. I will assume that as an outsider, I will assume that everything has been done properly. I need not go and see whether resolutions are properly passed or not. However, and moreover, that will protect the outsider against the company. If company do not pass any resolution as required by memorandum articles, outsider will not get affected because I presume that you passed. Because you presume, I read memorandum articles, though I didn't read. I will presume that you pass a resolution even though you did not pass. Okay, that's not my duty to check whether resolutions are passed or not. Now, however, indoor management will not work in three cases. Number one, knowledge of irregularity. Means if the outsider know that resolution is not passed, sir, how would the outsider will know, sir? Here outsider means inside company, outside, not like that. Company is a separate legal entity. Directors are also outsiders. Say. For example, company enters into contract with directors. Okay, company did not pass a resolution. Okay, outsider being director shall not tell that memorandum I read, articles I read, assumed that resolution passed. How can you assume? You are a director of that company? You know whether resolutions are passed or not. So if the knowledge of irregularity is there, protection not available. Next one, negligence. Whenever transaction is entered with the company, outsider should first ask the person who you are. For example, there is a company called a TCS. Yeah, understand this way. TCS is there. Which company? TCS. I came to you. Everyone, listen carefully. I came to you. I said, I gave you article. I gave you memorandum because online I downloaded. I downloaded AOA. I gave you MOA. I gave you AOA. Imagine seriously. I came to you. I gave MOA of TCS. Sir, how available to you? Public document. Anyone can download. I gave you MOA of TCS to you. AOA of TCS to you. I gave both the documents. I said, read. You read. Okay. Then you asked me, why you gave this? I want loan. I want loan. You asked me, oh, loan, huh? Then give memorandum objects clause. I will check in the objects clause. Loan taken is not is there or not. You check the loan. Loan can be taken by TCS. Give the articles. Articles special resolution is to be passed. Okay, I assume special resolution is passed. How much loan you want? You ask. I said I want 1 crore. You gave 1 crore check or 1 crore cash. Something you gave. I encashed. I took money and ran away. Okay, I am nobody, I am some person. Okay, after few days you went to TCS and said, give me 1 crore back. TCS said, yeah Rani, who are you? Okay, TCS asked, who are you? You said, who am I? Yeah, you took money from me. Yeah, company said, I took money from you. I said, who are you? Yeah, then you said, Are I gave to some person, Kaushik Mukesh, on that day. Who is Kaushik Mukesh? He said that he gave me memorandum and articles. That's why I gave loan. Road side la anyone can get public document. And to anyone you will give, basic suspicion should be there. And the point is, memorandum you have to read, articles you have to read. You should understand in right sense. Even before all these things, so who came to you first? Ask him who you are. Think whether that fellow will have a right to take loan or not. Roadside la some person comes to you, tell the name of TCS. Okay, outside public document la these are available. You will give loan. For that company will not be responsible. Means outsider should not be that much negligent. So first inquire who he is. After that memorandum articles will come into question. If with a minimum of effort, irregularities within a company could be discovered, the benefit of indoor management would not apply. The protection of this rule is also not applicable in circumstances where company does not make a proper inquiry. Next. Forgery. In forgery cases, illegality will be there. Indoor management does not work. And again, OPC. Again, holding company, holding in subsidiary, subsidiary holding. Mr. Aditya had incorporated a one-person company on 7/7/21. Mr. Yash was named as a nominee in the memorandum of the said one-person company. Now, Mr. Aditya, considering the perpetual nature of form of business, decides to appoint ABC Private Limited as a nominee. ABC Private Limited cannot be because nominee must be a natural person, Indian citizen and a resident who stayed in India for not less than 120 days in the immediately preceding financial year. Okay, therefore, can be appointed, cannot. ABC as a nominee is not valid. Next, Mr. Abhi is a chartered accountant and MBA by profession. Has been appointed as a executive director on the board of XYZ. His job profile includes advising board of directors on various compliance matters, strategies, business plans, risk matters relating to company. Keeping in the view of above position, whether Mr. Abhi can be classified as a promoter of ABC, promoter of XYZ Limited. Please examine the same under the provisions of Companies Act. Read the question first. Okay, so listen. First, we need to know who is a promoter. As per section 2 clause 69, promoter was defined. Who is a promoter? Promoter means a person who is named as such in the annual return or in the prospectus. That will not apply here. Next, who has control over the affairs? That concept also will not apply. Whose according to whose instructions board of directors are accustomed to act. Accustomed to act. Okay. Provided that nothing in subclass C shall apply to a person who is acting merely in a professional capacity. Okay, means when an advocate gives some advice, anyone will follow. For that only we will appoint advocate. That does not mean advocate is a promoter. Here, Abhi is a chartered accountant and MBA. He was appointed as a executive director. His job profile is advice board of directors. Whenever we appoint one person to give advices, we appoint to follow him. Just if I follow, he will become promoter. So therefore, will not be classified as a promoter. Next. One of the matters contained in the articles of the Dhiman Foundation, incorporated as a limited company under Section 8, was altered by passing a special resolution. Means articles are altered by passing special resolution. Intimation of the same was given. However, such alteration was opposed by Dwaj Company, a partnership firm which is its member, that such alteration was not valid. Advise as per the provisions whether contention of Dwaj Co. was valid and whether it can be member of such company. Section 8 company la partnership firm can become a member. Okay, according to section 8, a company registered under section shall not alter its memorandum and articles except with the approval of central government. Section 8 company can alter its memorandum, but without permission of central government it cannot do. Okay, however, firm can become a member. Finally, also section 8 company allows the firm to become a member. As per the provisions, it is necessary to take the previous approval of central government. Contention of Dvachi Limited is valid. Next. Yadav Dairy Products Private Limited has been registered in its articles along with memorandum at the time of registration of company in December 2014. Now the directors of the company are of a view that provisions of articles relating to the forfeiture of shares should not be changed except by a resolution of 90% majority. While as per section 14 of the Companies Act, articles may be changed by special resolution. Hence, one of the directors is of view that they cannot make a provision against the Companies Act. You are required to advise the company on this matter. Read. Yadav Dairy Products has registered its articles along with memorandum at the time of registration. Now the directors of the company are of a view that provisions of articles regarding forfeiture of shares should not be changed except by a resolution of 90% majority. Okay. So while as per section 14, articles may be changed by passing special resolution only. Hence, one of the directors is of view that they cannot make a provision against Companies Act. Listen, there is a section called as section number 5 which talks about entrenchment provision in the articles. What do you mean by entrenchment provision in the articles? Entrenchment means certain provisions in the articles we can make them more restricted than special resolution. Means what? Generally alteration can be made by special resolution. However, board of directors, if they feel that certain articles should not be changed so easily, then what they will do, they will put a entrenchment. Means it's a shield. Okay, it's a shield. They can put a shield to the articles. What they will tell, these provisions, for example, there are 100 points in articles. They can tell point number 16, point number 32, point number 64, point number 96. These 4 points cannot be changed unless and until you take 90% majority or 95% like that. Whatever they want, they can write. It should be more restricted than special resolution. Can they do? Yes. Entrenchment can be done. So whenever provisions are entrenched, they can't be altered with special resolution. They should require restrictions more restricted than special resolution. Special resolution na 3/4 permission is required, 75%, but here 90%. Valid or not valid? Yes. But how to insert the entrenchment? Now we spoke about how to alter the entrenched provisions. Okay, so how to insert entrenchment? Entrenchment can be inserted at the time of registration of company. If you wanted to insert the entrenchment after incorporation, in case of private company, unanimous approval is required. In case of public company, special resolution is required. So just now you said special resolution can't be done. Special resolution is not to alter the entrenched provision. Special resolution is required to a public company to insert entrenchment. After inserting it, if you wanted to alter the entrenched provision, then it requires approval more restricted than special resolution. That's what they wanted to tell you. Remaining all are just small points, whatever we discussed now. Same concept. Okay, again, entrenchment provision, all these things are getting repeated. Just read them and understand the concepts clearly. Don't leave this chapter. All the points, important contents I have covered here. So the lesser important points, everything, just read this particular document and complete it. Okay. Thank you very much.